point where we don't look at addiction as because you use drugs. Hi everyone. Today we're going to talk about what each court date in the dependency process means. Let's get right into it. So in the beginning, they set a 72-hour hold, which isn't a court date, but it is an administrative hold put in place by Dcyf that gives them the right to hold your children for 72 hours. They have to bring the matter before a judge within 72 hours. It has to go to court in front of a judge within 72 hours. This is where the clock starts, you guys. Within 72 hours of removal, you will have a shelter care hearing. They are required to do this. They are not required to completely explain what this means. It was very vague to me. I was very scared, rattled. I went to court and I didn't understand what was going on. I didn't realize what shelter care meant. And I think that they do this on purpose. Some counties are required to educate parents immediately on what each court date means, what the process looks like. Not every county is required to do that. That is one thing in our system that needs to absolutely change. There are support systems, resources that you can reach out to if you happen to come across the pamphlet in your courtroom, or you happen to join the right dependency CPS group on Facebook, or somebody you know mentions it to you. Sometimes there are good caseworkers that relay this information to you. It should be a requirement if the education isn't a requirement, in my opinion. But in our county, for instance, we have Parents for Parents, and it's a nonprofit with parents that have been through dependency, helping other parents walk through the whole process. They have courses that educate you on what the whole dependency process looks like. I reached out to them. I found it very helpful. So at the shelter care hearing, it is a hearing where they decide whether or not the child should remain out of the home while the case proceeds. They go over things like, was removal necessary? Where will the child be placed during the case? And they're supposed to prefer relatives or other suitable persons that you know that you want first before foster care. It goes over the basic first layout of what visitations should look like. Visitations can change as the case proceeds, but this is the initial, here's what we are required by law to give the parents. It's not pretty, you guys. It's not a pretty situation to be in. And it's usually the minimum. The bare minimum, which for us was 6 hours a week. And it's to maintain the relationship with the parent. It's to maintain the bond, is what they said. And I thought to myself, how do you go from being with your child 24 hours a day, 7 days a week, to 6 hours and maintain that bond? That's absolutely ridiculous. This hearing also goes over what services the parents need immediately. So this is where they will probably drop words like get a drug evaluation, get a mental health evaluation. They are not legally allowed or qualified to tell you you need to go get treatment. They have to say go get an evaluation and follow the recommendations of those evaluations. Depending on where you're at, it can be at a place that you choose. Of course, if you are addicted to drugs, my recommendation is always get clean immediately. So many things can be prevented. So much heartache, so much time your children are away from you can be limited if you get that help that you need right away. Do it. Do it. It's hard. It's scary. Do it. Always my first recommendation. Go get that help. That being said, let's move on. I like the word services too. I like how they use services. It's like, I don't know. It always kind of irked me. What services does the family need? Services is such a blanket statement for so many things that they could be talking about. We'll go into that later. So at this hearing, Dcyf also has to show that for the child to continue and remain in the home would be contrary to the child's welfare. So you have the right to appointed counsel at this hearing if you can afford one. If not, one will be appointed to you. Will you have a chance to talk to them before? Maybe like for 5 minutes in a room right before you go in there and you're freaked out. So that's awesome. The judge can order the child returned home if the removal was unjustified, or if you can prove that the home is safe for them. If you have a safe person there that is sober, in a normal state of mind, capable of caring for your children, that's one avenue you can try to go. If you are going immediately to treatment and that safe person will be the one remaining there taking care of them, that's another argument you could make. Those are really the only ways to go about that I can think of, or that I've seen happen. If I'm missing things, please drop it in the comments below. I want to give you guys the best information I can from my experience, from the information I have that is verifiable online, on documents, on laws, on everything. This is also the hearing where a CASA, which stands for Court Appointed Special Advocate, or a GAL, which is the guardian ad litem, will be appointed to your child. If your child is 8 years or older, you can request that they have their own lawyer. The difference between a CASA or GAL and a lawyer, the CASA or GAL is responsible for the child's best interest. A lawyer can speak on what the child wants. So it's a little different. These first shelter care hearings are very fast, very informal. Like I said, you might only have about 5 minutes to talk to your attorney that you just met in a room right before the court starts. Usually these are only like 10-15 minutes long, these hearings. Within 75 days of the shelter care hearing, you will have a fact-finding hearing. This is an official dependency hearing. This is where they look at all the facts, look at all the evidence, accusations, investigations done by Dcyf, any proof, documentation you've brought them on the contrary to what they're trying to say, and they decide if dependency should be established. At that point, it means your children are dependents of the state. The state has custody of your children. You still maintain certain rights, like the right to have knowledge of all of your children's medical appointments, things going on in school, the right to attend the medical appointments, I believe. If not, you can request it, depending on where you live. I was able to request that I be present to all their dental and medical appointments. You have a right to ask for anything, and you should. You should ask for anything you can think of that would make you feel comfortable and like you still have a part in your child's life, because reunification is the goal. So at my first hearing, I asked, can they maintain their doctors they have now? Because it's not far away. Why would we change that? I said I didn't mind about the dentist if they changed their dentist to make it easier for the people who are caring for my children. This is at the shelter care hearing that I asked all this, because at that point I didn't realize that I could still be like, no, this shouldn't have happened, even though it should have, you guys. It was the best thing that my children get removed. It's not easy to say that, but look at where we are today. It needed to happen. We needed that time to work on ourselves, to get the treatment and help we needed so that we could be the best possible versions of ourselves for them. That being said, I requested knowledge, information on everything that would happen with them at school. I requested that, I think that was it. If anything comes back to me, I'll let you know. For a child to be declared legally dependent under Washington state law at the fact-finding hearing, they have to have been abandoned, been abused, neglected by a parent, guardian, or custodian, or have no parent, guardian, or custodian capable of caring for them. So both at this hearing, and if you're gonna get clean, you guys, do it before this hearing. At this hearing, both sides present evidence and witnesses. You have the right to question the witnesses they have. DCYF carries the burden of proof by preponderance of evidence. Let's unpack that. So, preponderance of evidence means DCYF only has to show it is more likely than not, essentially 50.01% or more, that the child meets the definition of dependent. That is the same standard used in a civil lawsuit. So most advocates argue that this is a really low threshold. And look at you guys. Think of it like the moment that dependency is filed, the trajectory towards termination of parental rights has already begun. It is your job to stop it. Do what you gotta do. I know I keep saying that, but. So, most parents enter an agreement of dependency. I did. I didn't really think I had grounds to stand on to contest it. Some people are scared that they might start off on a bad foot with their caseworker if they contest it for the duration of the case. I don't think that should be allowed. You guys, come on. How can you be upset at a parent for being like, no? And then they look at agreeing to dependency as a sign of cooperation. That's what I was thinking, and that's why I did it. And like I said, I needed it. But I've seen situations where they take advantage of your fear, okay? Don't let them do that. But if you need it, here's the messed up part, you guys, is that I think the system should be set up so that when parents need this help, when I knew I couldn't get clean because I had 3 children and I didn't have the time to dedicate to that recovery, to getting through the brain fog, the withdrawals. I didn't have the time to dedicate to that. I needed somewhere for my kids to go, okay? I'm scared to ask anybody I know. It shouldn't be like that. It shouldn't be that you're scared. If you need that help, because can we please get to the point where we don't look at addiction as because you use drugs? I didn't wake up and say, this is going to be what I'm going to do with my life today. Everybody's going to be so excited. This is the best move for my future and my family's future. No, I didn't want to do it. I didn't like it. I hated every day of it and I wanted out of it. And I didn't know, I was so lost and depressed. I didn't know how to get out of it. And I've done it to myself multiple times. And I wish I had the answer for why that happens. I wish I had the answer for why the cycle of addiction continues. Why we do go back. I can tell you, I'm doing everything in my damn power to not go back this time. But can we stop looking at people that have an addiction as, can we please? Okay? Parents should be able to call. We should have a system that's set up so that parents can call and say, look, I need help, but I need to know you're not going to keep my kids from me. I had to get that out. Sorry. I feel very strongly about this. Because if it was set up that way, think of how many more people would be calling in. Think of how many less children would be getting hurt. Think of how the reunification rate would increase. Keep watching for another video because I'm going to talk about the history, the evolution of child welfare law. Okay? That's going to be a good one. So like I said, at this 75-day fact-finding hearing, parents can contest and present evidence, or you can enter an agreed dependency. Sign and say, yes, take my kids, you already have, let's do this, I need this help. Give over your trust, faith to the system, which doesn't work out for everybody. I was blessed with an amazing caseworker. I can't say her name. I wish I could. She is amazing. I was blessed with an amazing guardian ad litem. I can't say her name. You know who you are. I was blessed with caregivers that wanted my children to come home to me. I'm fighting for the people that don't have that setup. Because I don't know how differently our case would have gone if we didn't have a guardian ad litem, a caseworker, and caregivers that cared and supported us. Say dependency is established at this point. Now we're moving on to the other hearings, okay? If dependency doesn't get established, then I think they do another fact find. Hold on. Let me fact check this real quick. Hold on. Because like I said, I signed the dependency order. Okay. This is interesting, you guys. If Dcyf cannot prove by a preponderance of evidence that dependency should be established, and you do not enter an agreed order of dependency, and say you come to court prepared, you guys. Say you come to court and you're like, I've done this treatment, I've submitted this many clean UAs, I've submitted this many clean mouth swabs, I've done a drug evaluation, I've done all these things. What? What now? Here are these people that can speak on my behalf. What? I want to hear from your witnesses. And Dcyf can't prove dependency should be established. So at the fact-finding hearing, if that happens, the judge enters a finding of no dependency. The dependency petition is dismissed. The court loses jurisdiction over the family. The child must be returned to the parents. This is one of the rarest cases, you guys. This doesn't ever happen. This is so rare that this happens. So they're hoping that you'll just enter that agreed order. Any shelter care order dissolves. The dependency case is closed. So effing do what you gotta do before that hearing. Wish I would have. Do it. Do it. So obviously that's the goal, you guys. Okay. Dependency has been established. 14 days later is the disposition hearing. So at this hearing, a service plan should be ordered by the judge. It's called an ISP, an individualized service plan. This goes over specific services that they're requiring of the parent, the permanency goal, which at this stage is usually reunification, continued placement of the child, where the child will continue to remain for the duration of the case, and visitation schedule. So at this point, I would ask for more visits. I did. And I think they upped it just a little bit. I was always asking for stuff. I was like, what can I get now? I'm doing everything and more. I always made sure I was doing more than what they were asking. I did everything they asked and then some. And I documented everything, you guys. Document everything. So important. And bring it to court. Don't bank that they're going to do it. Don't bank on anybody doing their job. You are your best advocate, okay? Bring your stuff to court. Your proof. That's what judges look at. They look at proof, okay? I can't tell you how many times we were in court and I had my case like this thick of paperwork with me every time. And they were like, well, we don't know about this. And I flipped open my little packet of papers and I was like, actually, I do. It helps. Do it. So for your ISP, Dcyf must make every reasonable effort possible to offer these services to you. I like the ability to go choose the treatment center I wanted to go to myself. Honestly, I didn't want to drive 30 minutes away to a treatment center when I'm just getting clean, trying to get on my feet, broke, And that's not realistic, okay? Not realistic. I chose a treatment center in the city I live in. Loved it. It was amazing. So if your insurance is going to cover it anyways, go find this stuff yourself if you can. So every service requirement in your ISP at this hearing or from this point forward will be the benchmark for what they will refer back to. It's your roadmap, you guys. As you're accomplishing these things, they're looking back to this original plan and asking, okay, so where are they at? What have they done? What haven't they done? Okay? And you can refer back to it too. That is so important, because don't be surprised if along the way they try to bring up new things. They're like, oh, I don't know about this. Oh, well, they were a little irritable at their visit. Or, no, the original safety concerns, the original service plan, that's what they're supposed to refer back to. No parent is perfect. No day-to-day life of a family is perfect, okay? They're going to be trying to look for that. A lot of them are. Not all of them. But a lot of them are going to be looking for this picture-perfect perfection that isn't real, okay? So make sure you refer back to the individual service plan and the original safety concerns as well, okay? If you decide to go with just dependency, like you don't choose a therapeutic court like we did, they are required to give you review hearings every 6 months. That's not often enough, okay? That's not often enough. You lose hope. You lose hope when you're only checked in on and things are only updated and changes are only made every 6 months. What is that even? Are you kidding me? Now, you got to ask questions. I found out by asking questions that Dcyf is able to increase visits and make modifications to the visit schedule at any point in time. Does that mean they're going to? Depends. I highly recommend a therapeutic court. You get to request to have family team meetings every month with our courts, where you get to be like, look, I want this now. Or I need to know what you guys need to see for this to happen. I was always like, I want this. And then what do you need for this to happen next? I was one step ahead because I want my babies. You know what I mean? Come on. So you also get the therapeutic court coordinators. They get to help you. They have extra things they can help you with. They have clothing closets. Ours has like different incentives at each court date if you come in person, because you can zoom in sometimes. We never did, except for like one time when the kids were sick. We go because it's good. And you're showing other people this can happen. This can be done, right? And you have a better voice if you're in court, in person. They can see that you're doing better. They want to see that. So at these 6-month check-in hearings, if you don't choose a therapeutic court, these hearings are for them to review the case, to assess whether the case plan is working, continue to assess whether the child's placement is appropriate, and to assess whether parents are making progress. And you can imagine with hearings 6 months out, they don't expect to even be looking at your children going home once dependency is filed for at least 6 to 12 months. Remember that fact-finding hearing is 75 days from the date of the shelter care hearing. Get clean. Or whatever it is you need to do. Do it. So at these reviews, they want to know if the child's safe and thriving in their current placement, thriving to the best of their ability, right? Like, this is another thing that always got me. The whole time I'm like, of course they're not thriving. They don't have us, you know? Is Dcyf making reasonable efforts to reunify? The law states they're supposed to, as long as you're doing what you need to be doing. Is the parent engaging in services? You gotta do that shit now. The shit that's on your plan, you have to do it. You have to. Don't try to think you don't. Don't try to get out of having to. Just do it. What progress has been made? Does the permanency goal still make sense? They're gonna be evaluating if they should start looking at terminating your rights or guardianship. Don't let it get there, you guys. Has visitation been appropriate? So at this hearing, they can make changes to all these things, okay? And these hearings, again, happen every 6 months unless you're in a therapeutic court. Then depending on where you live, they happen more often. Guaranteed. But I don't know how much more often. Depends on where you live. Within a year of removal, a year from the day they were removed from your home, they start looking at a specific permanency goal. And that's usually reunification, termination of parental rights, guardianship, or adoption. Termination of parental rights. This is the last hearing possible. You know what this means. Let's not let it get there, okay? Again, reach out to support groups, join Facebook groups, reach out to different, ask questions, you guys. Ask about different options for different nonprofits and things in your area. Every area is different. Please comment below. Please reach out to me. I want to help. I want to talk about more topics that will help. I care so much. And I have been through this, okay? I'm rooting for you guys. Like and subscribe. Thanks.